Welcome to In the Name of the Law with your host, Liisa Speaker from Speaker Law Firm. Joining her today is Sinas from Sinas Dramis Law Firm, along with Mary Chartier and Takura Nyamfukudza from Chartier Nyamfukudza PLC. Now let's discuss some remarkable stories and real cases.
Welcome to In the Name of the Law. Today's episode, we're going to talk about criminal cases against librarians, understanding our auto insurance no-fault policies, and mandatory shared parenting legislation.
In the name of family law.
Hello, we're switching gears today in the name of family law because we're going to talk about legislation that affects family rather than cases. And I have a very special guest with me today, James Chryssikos. He's a family law attorney. He's been an attorney for over 23 years, and he's very active in the State Bar of Michigan's family law section, and that's how I know Jim. He is an attorney from Troy, Oakland County, Michigan, and we are here to talk about mandatory shared parenting legislation that we don't have in Michigan, but that has come up multiple times. So first of all, welcome, Jim. It's so good to see you.
Thank you. Thank you for having me.
And I wanted you to, could you just tell the audience what does it mean to have mandatory shared parenting, or as sometimes it's known, mandatory 50-50 custody legislation?
Well, the way these bills have been drafted in the past, they are structured so that anyone involved in a divorce or custody case, there would be a presumption of shared physical custody, and in most cases, equal parenting time. Now that's been defined differently over the various drafts of these bills, but that's the essential part of it, is that there would be mandatory equal parenting time, which can only be overcome by proving by clear and convincing evidence by one of the parents that it's not appropriate for their family.
So we mentioned that we've seen various versions of this bill come up over the years. Can you give us some data about how many times similar legislation has been brought to the Michigan legislature?
Well, I've gone back as far as 2005. I've been involved in the family law section. Well, I've been practicing for 23 years, like you said. I've been involved in the section directly in the council for about 9 years. So I've gone back. It's been an issue almost my entirety of serving on the family law council. I've gone back to 2005, and I could see at least 7 drafts of a mandatory shared custody bill over that period of time. So 7 since 2005. And legislative cycles are 2 years. So that means every single legislative cycle, except for maybe 1 or 2, there has been a draft bill of that nature.
So I think part of what I want to accomplish today is to help people understand why the family law section has consistently opposed the proposed legislation for mandatory 50-50 custody. And I think maybe we even have maybe a solution that would solve the concerns of the advocates and the parents who are trying to get the 50-50 legislation passed. So let's just take a deeper dive into some of the reasons that, some of the things that the proposed legislation, and there is none pending right now.
No, there's
So we're
not.
just kind of looking at past versions of it that we've seen over and over again
Right.
almost every 2 years. Some of the things that those pieces of legislation require and why that might be a problem in the life of a family. So I guess I'll just throw off one idea. You already mentioned a rebuttable presumption, but what does that mean when, if it's automatically going to be 50-50 and then, but it can be rebuttable? What does that mean to a family that has to go to court?
Well, what it means is that in that custody case or that divorce case, the court will assume, without anybody having to prove anything, that equal parenting time is what's in the best interest of the children. If either parent disagrees with that, then it's that parent's responsibility, their burden of proof, to demonstrate to the court and to the other parent why that's not the case in their specific situation. And there could be a lot of reasons why equal parenting time is not in the children's best interest. But the point is, it places that burden, which can be a very heavy, difficult burden, if it's clear and convincing evidence. That's just a notch below beyond a reasonable doubt, which we have in criminal cases. So by clear and convincing evidence, that parent must prove to the court that equal parenting time is not in the best interest of this family and those children.
Well, let's talk about the best interest of the children, because we look to our judges, and maybe sometimes it's not a perfect resolution, but we look to our judges to analyze the facts and then come up with a decision that's in the best interest of the children. How does the mandatory shared parenting legislation basically take the children out of the equation? Is that a fair statement?
Well, let's start with the fact that vast majority of divorce and custody cases are settled out of court. So judges make very few decisions when it comes to custody of minor children. So let's start with that baseline. And then from there, the reality is that in Michigan, we already have a custody statute. We refer to it commonly as the best interest factors that judges must evaluate each and every factor. That statute, as it exists today, is completely gender neutral, provides no presumption of mother or father, and of course now we have same-sex marriages, so mother and father isn't even applicable in all cases. But we currently have a statute and a statutory framework that provides no favorable treatment to either parent. It's completely focused on what is in the best interest of the children, which is really, if we were going to get all sides together on this debate and discuss what should a bill or what should a statute regarding custody look like, I think we would all agree that it has to be focused on the child or the children. And that's what we have.
So I understand that the proponents of the past versions of mandatory 50-50 custody have, one of their arguments has been that a lot of judges are stuck in the past. And for me as an appellate attorney, I've seen both moms and dads who are appealing an adverse decision, but I think a lot of it is, the dad's the working parent, and maybe judges instinctually just do every other week in a parenting time. And for a dad who's been living in the house and has been very involved, that's kind of like they're getting the short end of the stick. I think that's what the advocates are putting forward, and that the judges are stuck in the past. How do we get past the judges maybe looking at just how their feelings are versus what the law actually says? Because as you said, it's gender neutral.
Mm-hmm. Right. Well, first thing I would say is that I think as society moves forward and we're going from the traditional primary breadwinner to stay-at-home parent model to a dual parenting model, I think court decisions are starting to reflect that, and the numbers bear that out. Statistics show that joint custody arrangements are increasing every year as we move forward. So I think the issue, if there is one, is resolving itself in a lot of ways. The other way that this should be resolved is by, right now we have a family division of the circuit court. Most counties have their own family division. The idea being one judge for one family, and that judge is a specialist in the area of family law. That isn't happening, and it isn't working out in every county of the state. Those assignments, those judicial assignments, are fluid. So you may have a family court judge who's a family court judge at the beginning of his or her tenure, and then they move to the civil docket, the general civil docket, and new judges come in, either elected or appointed by the governor. They're typically, often is the case, appointed to a family division seat initially. They learn how to be a judge, they move on to general civil or criminal or wherever they aspire to be. So we need to eliminate this system that we currently have, where it seems like the family division of the circuit court is the proving ground, the training ground for new judges, some of whom have little or no family law experience. And to their credit, they learn quick, and many of them become very good family court judges and stay there. But we need to really have a dedicated family court, like we have a dedicated probate court.
Right. Well, and thank you for bringing that up, because I think the family law section sees instead of having to go against 50-50 mandatory legislation every 2 years, we are working on trying to come up with a bigger solution that would resolve the concerns of the proponents of that mandatory shared parenting, but also improve the lives of not just the families who go before the family division court, but also the attorneys who are representing them, by having a dedicated family court, a true one with experienced judges who have experience in family law.
Yeah.
So I think the data, thank you for bringing up the data as well, because we did dig into the data, and we found out a lot of the judges who didn't have experience in family law were the ones that were being reversed on appeal because their decisions didn't follow the law.
Yeah. Experience and predictability will lead to better outcomes. Definitely.
Thank you. And the last thing I wanted to point out, and I know you and I talked about it, but the mandatory legislation does not take into account a lot of factors like domestic violence, substance abuse, mental health issues. And that's another reason why it becomes complicated.
Yes, absolutely. It does depend on there are different drafts of these bills. We've seen various types of bills over the years. Some of them do, some of them don't. Some of them just add a factor or add a presumption, but keep those factors. But it's going to create a lot more litigation than it's going to save, in my opinion.
In the Name of Family Law is brought to you by Speaker Law Firm. In the Name of Personal Injury Law.
We all buy auto insurance and we think we have full coverage, but do we really understand what is in our auto insurance policies? Today I have with me Steve Sinas of the Sinas Dramis Law Firm, and he's going to help us better understand what is actually in our Michigan auto insurance policies.
Thanks for having me on.
Great. So first, what is an auto declarations page?
So when you buy auto insurance, your insurance company will either send you electronically or through the mail a copy of your policy, and also something that's known as a declaration page, which summarizes the coverages you have bought from your insurance company. And in my experience, when I counsel people following a car crash, most people don't know how to really interpret their declaration page because it's complicated. So I would encourage everybody to try to get theirs out and try to understand it as best as they can, and I hope this segment will help them do that.
We're going to put it up on the screen for everybody to see, but you can also go back online and watch this episode again when you have yours right next to you. So this will be really helpful, I think, for everybody trying to understand what they actually have. So let's go ahead and start talking about this declarations page that we see on the screen. What is this first line about liabilities to others, bodily injury?
Yeah, the first point I want to make in general about declaration pages is that they generally are laid out the same, but company to company they're done a little differently, and sometimes the language that they use is different. But in any event, with regard to liability to others under this declaration page, this is the coverage that applies in the event that this person who bought this policy made some type of mistake or was negligent and caused injury to another person, and then that person brought a claim against them. And what this person has opted to do is buy liability insurance limits of $50,000 each person injured and $100,000 each accident. So those are the limits that apply to this policy. That means if this person makes a mistake, the amount of coverage they will have to cover the damages of a person they injure is only $50,000. And by the way, this is the lowest amount that you can select.
The lowest?
The lowest amount.
Okay, so you can actually purchase more than this if you want to have greater protection.
And the point here is that this person has selected just to have this limited coverage. But the right to sue the at-fault driver provides the injured person the right to take that all the way to a trial, get a judgment against the at-fault driver, and if it exceeds the limits, then the at-fault driver may have to pay that judgment out of their own money. So that's why you want to consider whether or not you should increase your limits on your policy. If you have any assets, and just as a moral issue too, because we all drive, we all can make mistakes, and if that happens, if we've done the responsible thing and buy more coverage, we can at least provide more compensation to someone we may inadvertently injure.
Okay, well, let's go down to the next line. Limited property damage.
Yeah, one thing that's really surprising to people is that if they're hit by an at-fault driver, they come to learn that that at-fault driver only has to pay at most $3,000 for the vehicle damage that they've caused, your vehicle. And that actually only applies to the extent that you don't have your own insurance coverage. If you have collision coverage with your own insurance company, they don't have to pay anything. But the bottom line is that this declaration item is just talking about that $3,000 of damage that could be recoverable in a vehicle damage claim brought against this person.
Okay, and the next line is personal protection insurance, which we call in Michigan PIP benefits. What's that mean?
Right, so PIP benefits include several different benefits, but this line item, and this is how it's dealt with these days following the 2019 reforms, this line item is for the medical expense no-fault benefit. And this line item is saying that this person has limited their medical expense coverage to $250,000 per person injured in an accident. Now, important thing to understand, this coverage applies to the person if they were injured due to their own negligence or someone else's negligence. That's why we call it no-fault benefits. But what this person has opted to do is go down from the lifetime coverage that most people or everyone had prior to the 2019 reforms, and is now selecting to limit their coverage to only $250,000. That means if they're catastrophically injured and needed millions of dollars of medical care, no fault would only cover $250,000.
But just to be clear, it doesn't cost that much more if I want to select unlimited PIP benefits, right, or lifetime benefits.
Well, the reality is in the central Michigan area, that's true. In my experience, going up from the limited amount to lifetime doesn't cost you that much money. But depending on where you live, unfortunately, that increase could be significant. But I highly recommend, if you can afford it, to get lifetime coverage, because it makes a huge difference for those who are seriously injured.
Okay. What is the next line? Work loss and replacement services.
Those are another types of no-fault benefits. Work loss benefit is the income loss benefit. The replacement service benefit is a household chore benefit. So that person has selected those benefits. Pretty much you have to select those benefits, but that indicates the person has the right to recover those no-fault benefits.
All right, property protection insurance, here it's for $1 million.
Right, so if we are in our vehicle and we somehow are in an accident and our vehicle damages, say, a house or a building or other types of property, not an automobile, but in other types of property, this is the coverage that covers that loss. And it's required that we keep this coverage on our vehicles.
Okay. Uninsured or underinsured motorist coverage.
This one is really important to understand, and unfortunately most people don't really understand that they have it or what it really means. This is coverage that you buy yourself to protect you and your family in the event you're injured by an at-fault driver who doesn't have insurance or doesn't have enough insurance. If they don't have insurance, it becomes an uninsured claim. If they don't have enough insurance, it becomes an underinsured claim. And what happens here is that when you pursue your damages against the at-fault driver, you obtain whatever amount of money is available under their policy, and then you can turn to your own insurance company to pay the rest of your damages up to your limits. Now, this person bought only $50,000 of uninsured, underinsured coverage. That is not enough coverage. I recommend people try to bring that up to as much as they possibly can, say $1 million or $500,000. Because what that means is that, unfortunately, if you are injured, and the other unfortunate circumstance that can arise from that point is you find out you've been injured by somebody who doesn't have insurance, you know you've done the right thing and bought your own protection through your own insurance company. And your insurance company has to step in their shoes to pay the damages as if they were the at-fault driver. So it's a really important form of coverage.
To protect your own family.
Yes.
Right, okay. What's the line about comprehensive?
That is coverage we buy for our vehicle in the event it's damaged by weather aspects, other animal damage, damage that doesn't relate to actually vehicles striking our vehicle.
Okay, and then broad form collision?
That is coverage that applies when our cars are hit by other cars.
Okay.
And we can then recover damages from our own insurance company for the vehicle damage.
I'm going to skip down a couple lines to the statutory assessment recoupment fee. What does that mean?
Yeah, so this is a fee that we can all be charged because of the Michigan Catastrophic Claims Association. And this is part of the no-fault system, and that's just another aspect of our no-fault coverage.
Is there anything else that you want to point out about this form?
No, I just encourage everybody to take time to understand what they bought.
All right, well, I'm going to go home and pull up my coverage and watch this episode again.
Okay, thanks a lot.
Thank you, Steve.
Thanks.
In the Name of Personal Injury Law is brought to you by the Sinas Dramis Law Firm. In the Name of Criminal Defense.
Today, we want to talk about the First Amendment and laws that seek to criminalize freedom of expression. Joining us are criminal defense litigators Mary Chartier and Takura Nyamfukudza of Chartier Nyamfukudza. What are some of the areas that we're seeing new laws spring up?
One of the biggest areas is not even new laws, but prosecutors using existing laws to charge librarians with crimes. And that actually happened here in Michigan with a prosecutor threatening to charge a librarian because of a book that was on the shelf. And the prosecutor actually threatened her with accosting a minor for immoral purposes, which is a felony, which comes with potentially registering on the sex offender registry if she were to be convicted of that. And you have some laws and ordinances that different communities are trying to pass locally about books being banned from schools or public libraries. But threatening a librarian with accosting is a whole new level of an attack on a librarian. And I give that librarian a lot of credit, because the prosecutor kept saying he wanted to arrest her. And she was like, you know where I am. Monday through Friday, I'm at the library serving the community. So come and get me.
Wow. What does an accosting crime normally entail?
So ordinarily, we see these arise from circumstances when an individual goes online and tries to engage a minor in sexual intercourse. And we've actually seen it in instances where the person on the other end of the screen is not an actual minor. It's a police officer or a group of them posing as minors and posting photographs pretending to be somebody who they're not. I mean, I think we've seen the TV shows where somebody shows up to a house and then they're surrounded by people who are not minors. But typically, that is the circumstance in which these types of charges arise. And as Mary noted, one could end up being having to register as a sex offender, sometimes even for the rest of their lives. But yeah, at least for many, many years.
And the prosecutor threatened a librarian with this crime over a book, right?
Yes.
That's correct. And, ordinarily, in many instances, we've seen it where these books discuss people of color and just groups of people who are not popular. So the LGBTQ community are two common targets of these people. And I think, as Big Gretch famously said, right, no book has ever shot somebody or hurt anybody. So it's quite an interesting scenario. Yes.
And one of the things that you're seeing, sorry, Liisa, but one of the things that you're seeing that groups will fight to get books banned from the school library. And then they'll say, well, you can still go to the public library to read this book. We just don't want it in our school. And then the same group will want to get that book banned from the public library. And so then they'll say, well, we're not really banning it because you can still buy it or go online and order it. But the library is there for everybody. The library is there for people who can't necessarily afford to buy all those books. And the library is there and was there for me when I was growing up. We didn't have a lot of money. My parents never could have afforded to buy the books that they got for me from the library, or that I was able to go to the library and get. And it's this real homogenization of thought. If it's a theory or a philosophy that someone doesn't agree with, they want to ban the book, and they only want books that agree with them, which is totally contrary to the freedom that's supposed to be existing in this country.
And if I may add.
Yeah, of course.
I can tell we're really passionate about being anti-book banning.
Right.
And we're not just talking about a handful of books, 1, 2, or 3 titles. We're talking about thousands of books, Liisa, by authors like Toni Morrison and Margaret Atwood. People have tried and actually been successful over time, even banning To Kill a Mockingbird. I recently saw that here in East Lansing, which is a classic book about a trial, and it was banned because the subject matter was, guess what? About race.
Is this sort of conduct increasing? It sounds like it is.
It is. It's increasing all around the country. Michigan is one of the hotspots for groups trying to ban books, and in some cases being successful. I mean, it really is antithetical to the entire notion of the First Amendment and freedom of expression. And I know we've covered the First Amendment before. We've handled a lot of First Amendment cases at our law firm, and we've got a couple going on now. I mean, people have to have the right to express themselves. They have to have the right to read viewpoints that don't necessarily agree with them. And when you're trying to ban topics like race or sexual orientation or whatever it might be, I mean, you're really taking away from people an opportunity to learn. And especially for young people, we know that isolation for LGBTQ plus youth leads to suicide. And we know that there's bullying, and we know in schools just across the board, right? Isolation leads to increased violence and depression. So to actually take away books that address issues that young people are dealing with because it doesn't fit with some kind of really, homogenized viewpoint of what's going on in the world is ridiculous. And it's contrary to this country's founding principles. So when people get out to vote in November, any November that they go to vote for, they've got to look at, listen, this person might be saying they're anti-government, but when you are talking about limiting access to books and ideas, you're pro-government in the worst kind of way, because you want the government to start interfering in your private life. And that's problematic.
Right.
So what's the overall, or do you know what the overall most banned book is in the United States?
It's 1984 by George Orwell. Well, imagine that, right? 1984 is a book about a dystopian society where the government controls thought and individuals really have to kind of give up what they want, what they believe, what they think for the greater good of the government. So that is the most banned book in the country.
Okay, are there attempts to limit the freedom of expression ending? Is it going to end with just books?
No. You're seeing this across the board, right? Again, if it's not the way that some individuals want you to think, they don't want you reading books. They don't want certain lessons being taught in school. We're seeing that, right? In other states, especially, you can't use the word gay. They don't want to talk about the history of slavery in this country. It's literally part of our country's history. I mean, we saw one person say, and this was actually part of a lesson plan, but a legislator actually said, well, slaves learned valuable skills. You've got to be kidding me. They are slaves. Like, let's not try and put a positive spin on slavery. I mean, that's ultimately really ridiculous. You can't change the country's history. You can't change the history of the world. If you don't want to teach it in schools and you don't want libraries to host books about it and to have books there for people, I mean, you really are limiting what people can think about. And then one of the biggest areas right now are drag performances. You're having lots and lots of states enact laws that restrict drag performances, which across the board also limits, Shakespeare's plays. It could limit the movie Tootsie, but it really is a target toward LGBTQ people because a cheerleader at a national football game can get out there in a skimpy skirt and shake, their hips, and everybody's fine with that. But if you're a drag performer and you do that, you could run afoul of the law and actually go to prison. So this assault on our freedoms is extremely relevant, especially when people get to the ballot box and start voting.
So are these laws being challenged?
Yes, on the First Amendment, and those challenging the law have had success. And not to belabor the point that Mary made earlier, but there was a time when trying to learn to read was a capital offense, right? Slaves would be killed for that. And one person once famously said, if you want to hide an idea from a Black person, put it in a book, because if they found their face in a book, then, off to the gallows with them. So yes, this is very serious. And if we don't want to repeat our history, right, we've got to learn it.
If legislators want to restrict what you can learn about and think, they are not the right legislator to get elected, bottom line.
Right. Thank you both.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukudza, PLC.
Thanks for joining us on In the Name of the Law. See you next week.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.